Every Tuesday, we do bring an immigration update at 5 p.m. to 6 p.m. Central Time, and we do answer live questions. Emily, what do you have today to discuss?
Today, we want to talk about the importance of getting your H-1B extension or any extension filed early, making sure you get the result before your current status expired. Why do we keep mentioning that? What is the importance of it? We'll also talk about situations when you may reach out to your company's immigration lawyer and it could potentially backfire on you because that information may be taken to take action regarding your job. So we'll talk about what situations can happen there and what else you can do. And then we have a common situation, especially for people who have gotten an I-140 approved in the NIW or EB1A categories, maybe a couple years ago, waiting for their priority date to become current. Now it's current, but you're no longer with the company that you were with at the time you filed that petition. Can you still file the adjustment of status in that situation? Lastly, avoid international travel. If you are in the US, you should not leave as long as you're maintaining your status. It's not a time to go for visa stamping. It's not a time to take a holiday or take trips. We'll talk about why and the issues that come up for people who have been traveling.
Why do we have to repeat this all over again every time? Because we do that. A person needs to get the status extension done before the I-94 expired, because a lot of things can happen. Let's say you're working for company A and now the H1B is expiring in June 30th of 2026. You file an extension. Let's say it's a consulting company and now you're in July. The project is lost. They may have to withdraw the H1B. You may lose the job. They may have to withdraw the H1B. Sometimes even you may have a project. Maybe it's an in-house. Maybe it's a big company. What if it's been denied because there are some issues with regards to the bachelor's degree requirement, maybe your own degree requirement? Anything can go wrong. And if something happens and you get the denial after June 30th, that's when your H1B expires, then you don't have any option but to leave the country. Emily was telling just 2 minutes ago not to leave the country, but in that particular situation where you have the H1B denied after your I-94 expires, you may have no options but to leave the country. Now, once you leave the country, thanks to Trump right now, if you want to come back into United States on H1B, the company has to pay $100,000. Not many people we have seen, not many companies are ready to pay the $100,000 fees. We have not seen many companies willing to do that, though. And it's always what if you get denial before June 30th? Yeah, if you get denial, you can refile the same H1B extension. You can transfer to a different company. You can transfer to B1. You can transfer to F1. You can transfer to H4 or any other visa status you may be eligible for before June 30th. Now, once you cross the I-94, you get the denial, you are in big soup. And we have consultations every day. We do have daily Zoom calls where approximately about 100 people show up and we answer about 30 people every week. Every week we do answer 100 people here. We got 50,000 subscribers approximately for the YouTube. We have all these people giving us the feedback, and that's one thing that you can avoid is get the result before the I-94 expires. Wow, no, 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 no. My employer told me, and I know the law, that it is 240 days. I can continue working on the H1B after the extension is filed. What are you telling, Rahul, that after 240 days I can work? Yes, you may be right. But what if the denial comes in? What if you lose the project? So we advise strictly file a premium processing. If the company is not willing to pay the premium processing, you're allowed to pay the premiums. Of course, the company should allow you to do the premium processing, but we strongly recommend to get the H1B, L1, or any other non-immigrant visa. If you can get the result before the I-94 expires, you will be in a much better shape.
Yeah,
Emily?
I mean, we've been through the Trump administration before. I don't know if people have short memories or just weren't here during the prior Trump administration, but the number of people who got denials of their extension skyrocketed under the previous Trump administration because they eliminated deference to prior approvals. They changed policies. They required more documentation regarding employer-employee relationship. The types of adjudication were changing. They were looking at level one wage issues. more site visits, all of that was happening. And so the number of denials went way up. And, we're only 15 months into the Trump administration. We still have 33 months to go. I just did a webinar on that for some EHA attorneys last week. And 33 months is a long time. They can make a lot of changes in 33 months. Think of all the changes that have already happened in the last 15 months. It feels like every day something new is different. It's going to continue. We really haven't seen the major changes to H1B adjudications yet. We really haven't seen major changes to L1 adjudications yet. They're coming for sure. And so you don't want to be in a situation where you file an extension like you normally would, and all of a sudden a case that would have gotten approved 3 years ago is no longer approvable now, and you get that decision after your status has already expired. That means as soon as that denial comes, you're immediately out of status, but you are also accruing unlawful presence. If you accrue more than 180 days of unlawful presence, that triggers a 3-year bar. So you have to act quickly. We also see that USCIS has the ability to issue an NTA, notice to appear in deportation proceedings, if your I-94 has expired at the time they make a negative decision in your case. So those are a lot of risks to take. It's not worth taking those risks when you have other options. You have to file early, start the process early. You should be talking to your employer at least 7 months before your current status expires. With H1Bs, of course, you can only file 6 months in advance. You can only get the LCA so far in advance. So it does take a little bit of time, but you can be starting to gather the documents, gather the information around the 7-month mark so that you'll be ready to file at month 6 and get the approval before your current status expires. What about situations when you have a question, you realize something like I-94 issues is a common one, and your first thought is, let me call my company's immigration lawyer. They're the ones that handled my H1B, or they're the ones handling my case. Why can that backfire sometimes?
Let's say if the I-94 expires, though, they may not want to resolve the problem. They may want to get rid of you. There are easy ways which you can go to Mexico and come back and rectify it. But if you inform the employer's lawyer, though, the employer's lawyer may be under the obligation, they want to stop your employment. And at that point of time, if you want to travel outside the country now, under these emergency circumstances, we tell people to travel to Mexico and come back to rectify the I-94. It's very easy because the USCIS considers I-94 differently. The CBP, Customs and Border Protection, determines differently. They say whatever is in the I-797 is valid, but the USCIS says whatever is in the CBP is valid. So to rectify, it's always good to go outside and come back, even though you don't have a visa stamping. It's called automatic revalidation. You can Google it, the word I meant to say. Now, the problem is when you call the employer's lawyer, though, the employer's lawyer may try to rectify, may say, well, we are in big soup. You've been working for 6 months or 7 months illegally in United States. So let's terminate the job immediately. Then you will be in a big soup at that point of time because you cannot travel outside the country and come back because you don't have any job. Then you may have to leave the country at that point of time because you can't even, they may or may not be willing to file the H1B with non-proton argument, which is not a good idea. Also, let's say if you have any arrest record, though, it's better to inform it's better to contact a private lawyer to make sure everything is there before you go to your company's lawyer. Also, if there is any address, let's say for example the LCA location is in New Jersey, and it's from in-house, and now you are sorry, you're working from in your own apartment and your house, and the LCA location is New Jersey. Right now you moved to Dallas. You found out you did a mistake. What do? You contact the immigration lawyer of the company. The company lawyer may just say, pack your bags, we will fire you because you violated the LCA. We are out of status. They may rectify it. I'm not telling that every immigration lawyer, company lawyer may do the same thing, but they may try to rectify, or they may want to terminate you, though. No, the better solution would be if you contact an immigration lawyer. I would always tell them go back to New Jersey first, stay there for a couple of months before you do anything. That's what normally people outside lawyers will tell. So it's always good to contact when you are in soup to contact first a private immigration lawyer, then approach the immigration lawyer. Also, in situations like, for example, if the labor certification application has been filed with San Francisco, and right now you are in Austin, how do you approach them when they are filing the adjustment of status? I've seen some of the employees approach the company's lawyer. I am never going to move to San Francisco. It's a very expensive place. I'm well settled. My house, my wife, my kid, everybody's in Austin. I'm not going to move. Then the company lawyer may not be willing to file the adjustment of status because you don't want to move. Now, even though you're in Austin, you could possibly have a plans to move after you get the green card to San Francisco, and that may entail them to file the adjustment of status. The manner, the way you speak also will make a difference with the company's lawyer. Now, when you speak with the private immigration lawyer, everything is confidential. They won't release that information to anybody. Believe me, no private immigration lawyer will do it because its confidentiality is there with them. But when you speak with the company lawyer, though, the confidentiality may or may not be there. They may release that information. They may take their own decisions against you at that point of time. Because most of the corporate immigration lawyers act on behalf of that company. They work almost as an employee of that company. So we just want you to be careful whenever you want to address to the immigration lawyers. Certain times when you are looking into EB1C qualification to see into job duties, how they're footing into, you need to first understand what qualifies for an EB1C before you present yourself in front of the immigration lawyer of the company. Because if most of your job duties are only to do the routine, mundane job, then you are not eligible for EB1C qualification. You must be your most of your job duties to be supervising the other people, the percentage of job duties. So it's better to get it evaluated by a private immigration lawyer before you approach. There are many other situations. I just cited four or five of them, but there are many other situations that may fall into. So eventually, for all these things, for most of these things, you may still have to go back to the company lawyer, but it's always good to approach a private lawyer, then go there because it'll be easier to achieve what is in your best interest.
All right, next topic. Let's say you filed a national interest waiver, EB2 I-140, or you filed an EB1A I-140, and these are both self-petition filings. 3 years pass, now your priority date is current. You're no longer with the company that you were at when you filed that petition. And again, this is a self-petition. You filed it on your own. Can you still file the adjustment of status? Yes, you can, because these 485s do not require any supplement J. That's the only document that's needed from a company for filing the 485 in these categories. So it does not matter what your current job is at the time of filing. But what if, there's are cases where the NIW or the EB1A is actually filed by the company, where the company is sponsoring that? Raul, is it possible to still file the adjustment of status if you've left that company, even though they filed it?
The 485J instructions are very clear there. If you look into the instructions of the 485J on the USCIS, though, it clearly says that for the national interest waiver, for the EB1A category, you do not require any 485J to be signed. Now, this is even if the employer has filed. Let's say, for example, you have Facebook or Meta filing for the I-140 and the national interest waiver. Still, it does not require, once it's approved in national interest waiver or if it's approved in EB1A category, it does not require Meta to file a I-485J to file the 485J supplement. Let's assume that you're working with a different company, though. Can you file the adjustment of status? I don't see any reason why you cannot file the adjustment of status. Of course, they will look into whether or not you at this point of time are in the relevant field, working in the relevant field of national interest waiver or in the EB1A extraordinary category. Normally, I request people to write a letter and saying that I'm still working in a similar field, and if they are working in the similar field, and then submit it with the adjustment of status. That's all it is required. Emily, I've even filed for people who are on H4 and they did not even got their H4 EAD. They filed a H4. I even filed their adjustment of status. She wanted to move back to the EB1A category into the particular category, and she filed an adjustment of status as a primary applicant. Had no issues in approving the green card. And for the green card was approved in 3 months for that particular person, though, along with the husband. She is the main applicant, so I had no issues. And I just cited out to the USCIS official that the 485J supplement is not required. Here is the instructions for the 485J supplement USCIS website, and had no issues though. Now, is it a concrete test that absolutely there will not be a problem? There might be some hurdles. They may ask some questions about whether you're really working in the similar kind of profession, because and to see, and the USCIS may determine that you are working the similar profession, then you're fine. If they determine that no, you're not working the similar profession, there is a chance of denial. But for a majority or 95% of the people, it should be an approval if they are working in the similar field. Now, when they approved the national interest waiver, though, when they approved the EB1A, this is more about your caliber, though. What is your caliber? Is it in the national interest that your work is in the national interest? Is your work in the extraordinary field that you are in? It's not actually what the company is doing, it's more what the individual caliber is. Now, it's completely different when it comes to the EB1B, because EB1B not only says that you must be outstanding, the company must be in a research area, there must be other researchers working for that company, it must be sponsored by the employer. On the contrary to the national interest waiver, it doesn't have to be sponsored by by the company. It can be filed by an individual too. Even though company has sponsored, I don't see any problem in filing the adjustment of status when you're not working with the company. Same thing with EB1C. Now, that is a company sponsorship. It has to have a relationship with a company outside the country. You must have worked for the country outside the country. There are no such norms for national interest waiver or EB1A category. Now, EB2 and EB3, though, they have done the labor test. That means that there is no American worker available for the kind of job for which you want to do it. They did only for that particular company. That's the reason why the company needs to file a I-485J when they file the adjustment of status. Obviously, everybody knows that once you file the adjustment of status, after 180 days, you can move to a different company under the portability of AC-21 law. That's a different rule. But when you're filing for the adjustment of status, you need 485J if you are an EB1B, EB1C, EB2, and EB3, but not in the case of national interest waiver or EB1A category.
All right, moving on to international travel. We have both said since January 20th, 2025, if you are a non-immigrant in the US, maintaining your status and able to continue to maintain your status, you should not travel internationally. We still believe that, and we will continue to believe that for the next 33 months of the Trump administration. People always ask, well, how long am I expected to not travel? It's ridiculous that I can't go visit family or go to my home country. Until we have another president, I really think that travel is not a good idea. Of course, we did just mention automatic visa revalidation traveling to Mexico in very limited situations when you have to fix your I-94. That's a situation where if you don't fix it, you may be found to be out of status. That's a different issue. But if you are in the US maintaining your status and you have options to continue to maintain your status without leaving changes everything. It changes the whole calculation. You have much fewer rights when you're outside the US compared to when you're in the US. When you're in the US, all the Trump administration travel bans that he can do, all of his executive orders, generally do not impact you when you're in the US. That's why people can file in the H1B lottery. All of those filings are new petitions that are supposed to be subject to the $100,000 fee. Well, why aren't they subject to the $100,000 fee? It's because that's a travel ban. That's what Trump has the ability to do, is impact people who are outside the US. If you're in the US, maintaining your status. Once you leave, there's a lot of risk involved in getting back into the country, getting visa stamping, getting 221G, getting delayed, getting denied, inability to come back in because of some random travel ban that happens, getting your visa revoked unexpectedly while you're out. There are so many risks of international travel right now that is just not worth it in the vast majority of situations.
Just one guy calls me today for a consultation. He says, I have an appointment in October of 2026. I was able to manage the appointment for H1B. Can I travel? I said, no, you can't travel. Don't travel. Why? I said, because look, they're postponing the appointments. Oh, my appointment already got postponed one time. That doesn't mean they're not going to postpone the second time. So even if they do give an appointment, even if you go for an appointment, there's less chances for them to approve it right now because they have very clear instructions. Whatever they can do it to avoid you to come into the United States, they will try to do it though. There are people who will say, yeah, I already have a visa stamping, which is valid. I still say, unless it's an absolute emergency and you have a clearance from your outside lawyer to make sure everything is perfect, still, I suggest not to. But if it is very urgent, if you already have a stamping that is there, maybe. And for those people who are on F1 visa that are on STEM OPT or on OPT, definitely do not travel. Do not travel. Even if you have the passport stamping, do not travel. Absolutely no travel for you. Anybody who is going for H1B stamping, do not travel. I have an emergency and I have somebody serious there in India. Why can't I get a visa stamping? Because it's a real emergency. Here is the thing. It's a real emergency for you to go there. It may be real emergency for you to go there. There's no real emergency for you to come from there to here. Because if there is anybody serious, that is the person who is serious in India, not here. The seriousness is if you want to make an appointment, like for example, okay, there is an US Iran war going on, and you have some technology that will say the defense, one of the general will say that this guy's skills are absolutely needed to make sure that all those drones that the Iran is shooting out, this guy can just disappear them in an hour, matter of hour, if he has that much technology. Maybe at that point of time, they will issue an emergency visa for you, though. But otherwise, we recommend you are not, it's very unlikely you're going to get the emergency visa. Now, here's the thing. There are some people who are got outside the country. Their visa got revoked when they're outside the country. They're stuck there. There are people whose visa got postponed and got stuck there. There are people who have requested, I have an emergency to come back into the United States. My wife is pregnant and she's about to deliver. I need to be with my wife. Some of them were being granted. Yeah, we think so. It's an emergency. But then they said, no, we don't have any emergency appointments. So please don't travel. Do not travel. Do not travel. Do not travel. Do not travel outside the country. Do not travel outside the country. Please do not.
All right, before we go to
Anything more?
questions, I just want to give one last update. Right before we went live, the USCIS did announce that the H-1B lottery is finished. They have completed uploading all selection notices, so there are no more selections for this round of the lottery. In our case, all of our attorneys in our firm, the last time we got a new selection notice was Saturday morning. We did not receive any on Sunday, did not receive any yesterday. So we assumed it was over anyways, but we did finally get the official word. So if your registration still says submitted, it's over. There is not a chance for you to be selected in this particular lottery. Only if it already says selected as of this moment, then you can move forward with the next step. Now, there could be a second round of the lottery. That will not happen until July at the earliest. Is there a chance for a second lottery? That's really hard to guess because we don't know how many registrations were submitted. We don't know how many were selected. We don't know which wage levels they were. We don't know if they were bachelor's or master's. Out of all the years that we've had this electronic lottery to 2020 until now, there have been so far 2 years where there was a second lottery conducted. This year, I think, is the highest chance of a second lottery happening because there are so many new factors. So USCIS, when they're selecting, there's 85,000 visas. They don't select just 85,000 because they know that every year some are not going to file, some are going to get denied, some are going to get withdrawn, some are going to get revoked. And so they take that into account and actually select extra. So when all that is said and done, they end up with about 85,000 approvals. Now, this is a calculation that they do, it's a prediction that they make. They might be accurate one year, they might not be accurate one year. They might not select enough this year because this year it's a wage-based system. We don't know, whether employers are going to proceed to file after they got the selection. What if the job location changed? What if the job changed and they can't do the high level wage that they originally said they were going to do? What if the person is outside the US and the $100,000 fee is still there? It hasn't been blocked by a court. They might not file. For all of those reasons, when USCIS actually receives the petitions filed, they may find out, oops, we didn't get 85,000 approvals. We're short. We need to run another lottery. So that typically happens in July. So if your case is still showing as submitted, not selected, you're going to have to wait till July to see if maybe there's another round.
Emily, with regards to the B2, there are a lot of people that are calling our office. There are a lot of people that are messages. Yes, we, along with other lawyers, have said that you can file the B2 application until about February first week or second week of 2026. We have seen people filing the B2 applications, getting their B2 to H1B had no difficulty, but for February onwards, so second week or third week onwards, USCIS reversed its policy and they started issuing RFEs on the H1B. They started issuing notice of intent to deny the H1B because the B2 is still not approved. Of course, we have some victories and some getting denied for B2. Emily, what is the update on that though right now? What if I have filed a B2 and I have filed the H1B? Now I got a notice of intent to deny for the H1B. I got a B2 RFE. What's the solution right now?
Unfortunately, I don't know if there is one. We are, seeing that on the H1B, they're saying that because the B2 is not approved, we cannot grant the change of status portion of the H1B. That means they intend to approve it for consular processing. When you have a consular processing H1B that's filed after September 2025, that means the $100,000 fee kicks in. So unless the company is willing to pay $100,000, you may not have an option to get that H1B approved. And typically, because of the H1B filing, we're also seeing the B2 denial. Once your B2 is denied, your H1B is denied, you are clearly out of status. Definitely should speak with an immigration attorney about options, which are quite limited. It may need you to exit the US and not be able to come back on H1B until the $100,000 fee goes away. So we don't really have a good option for people who've already filed and are already in this situation. It's just luck of the draw at this point is what it feels like.
So if somebody wants to contact us thinking that if you are in this soup of B2 and then move from H1B to B2, while B2 is pending, you file the H1B, thinking that we are going to resolve it, we may not be able to resolve it though. So we just want to warn the people about it, give it the realistic expectations before you contact us on that particular thing. Go ahead, Emily, with questions.
Vero from X says, I filed an H1 extension. It's been 275 days. My current H1B expires July 2026. What are the consequences? I'm a full-time employee for that company for the last 4.5 years. The processing times every month are getting longer. So last month, it may have said that we're taking 6 months to process these cases. Therefore, you can't do a service request yet, but you might be able to next month. And then you log in next month and it says, now we're taking 7 months to process these cases. You can't do a service request right now because it's in the normal processing time. Check again next month. The next month you check it. Now it's saying 8 months is normal processing time. That's going to keep continuing. Just we know that from the Trump administration. So all that to say, best thing to do is upgrade to premium processing, as we said at the beginning. Get the decision before your current H1B expires in July 2026. You have plenty of time to do it now if you upgrade to premium processing. You've been your full time, you've been with the same company 4.5 years. Are you likely to get an approval? Maybe, but you're also potentially, we don't know how USCIS is going to change their adjudication trends, their policies. They make these changes that are not announced. Think of all the people who filed B2 applications because the USCIS was approving them and that was their policy. Now, all of a sudden, that's not their policy. Did they announce anything? No, they just started denying them. That's the same thing that can happen with H1s. We've seen it in the prior Trump administration. People who had been here 10, 12 years, getting their H1B extensions approved every 3 years, never had a denial, never even had an RFE. All of a sudden, their extension got denied. And then if the I-94 had already expired, there's nothing you can do. You have to leave the country because you are out of status and unlawfully present.
Rama has this question from YouTube that his H1B has been prudentially revoked because of any arrest record he may or criminal arrest record he may have. Are you seeing any problems in their visa extensions for a 95% of the people that we know about, especially if they are a DUI or something like that, where it's not a crime against moral turpitude, then we are not experiencing a denial for the visa extension. They're asking them to come for the biometrics, and people are scared. Oh, no, they are going to come and pick you up. No, for the DUI, we haven't seen any problem. And they will ask RFE to provide extra documentation for the case dismissal, but we have not seen a single denial for those kind of things. However, if you go outside the country, you are gone. You are not coming back. That's for sure. Until the Trump administration is gone, you're not coming back. We don't know afterwards how the things will turn. But definitely, if you have any travel plans, we don't. We tell you not to. But within United States, traveling is not an issue. Filing an extension is not an issue. Changing an employer is not an issue. Another gentleman asked this question. Rachan has 2206 is it risky for a person to change the employer in May of 2026? No, it's not risky though. Even though Emily and I have been cautioning you guys to get the result before the I-94 expires, though, surprisingly, we haven't been seeing the denials, Emily, like the way what we have seen between 2016 and 2020, is right, Emily? So
Right.
the amount of denials of H1B, what we have seen, we haven't been seeing that. One, because we used to go to court after the administration probably learned because we started going to court and started winning the cases there. I don't know why, but at least the denials are not as high as what it was in 2016 and 2020. Now, if for you to be on a safer side, if you want to change the company, the best safest is file a H1B transfer with the company, get the H1B approved. Voila, once the H1B is approved, you're free for the next 3 years.
Viraj says, I have EB2, EAD and AP that's good till 2029, priority date current. Also have a pending EB3 with the same priority date. Can I apply for an EB3 EAD as a safety net in the event of an EB2 denial and that EB2 EAD becomes invalid? Yes, you can. We have a lot of people that did that, especially that did the downgrade in 2020. And then when the priority date became current in EB2 in 2022, we filed a second 485, filed EADs and APs with those. So they have both. Yes, you can do that. Now, in a small percentage of cases, USCIS might say, we see you already have an EAD and AP valid till 2029. We don't see the point of giving you another one. And then they just deny the second filing or administratively close it. That doesn't mean anything's wrong. They're just choosing not to give you multiple benefits that you already have. But most of the time they are approving it. So I don't see any downside to filing other than, the cost of the filing fee in case you get one of the small percentage that's getting denied.
Krishna has H4 and EAD approved until April 7, 2026, but the I-94 is shortened only April 6th. Can you file an I-539 and the EAD and start working? I don't know whether he gave the proper dates or not. But if the H4 is only until April 7th, 2026, though, and your EAD is only valid until I-94 is shortened until April 6th, though. I mean, you don't have an H1B for more than 1 day. So probably I'm mistaken. Maybe I'm assuming that your H4 is valid until 2028. If that is the case, though, if the I-94 is shortened, the best thing is right now, before April 6th, you can travel to Mexico and come back. If you have a visa stamping until 2028, you can just travel to Mexico. If you don't have a visa stamping, then there are certain things that you may have to get a Mexican visa to travel. There are some solutions, but I actually need to know when your actual I-797 of the H4 is expiring.
Amit says, is USCIS still issuing H4 EADs if filed in premium along with the H1 and H4? No, they are not. They have a new excuse for why they can't approve them all together, and that is the photograph. So for all these years, 10 years of having the H4 EAD, we always submit your passport photos that you go to Walgreens, you go to CVS and get them taken yourself and send them in a little envelope. Now, since December, they've decided that that's not good enough. We can't really trust that those are valid pictures of you. Therefore, once you file your H4 EAD application, they will call you in for biometrics to take your picture so that they can put that picture on your EAD card instead of the picture that you send them. That is delaying the H4 EAD, so it can no longer be approved with the H1 and H4, even if you file in premium processing.
The CBP I-94 online expires in September 2026. After that, I did filed an H1B extension after he last entered the United States, which is expiring in 2028. Which one to believe? Now, if the H1B has been extended after you entered into United States, and the USCIS extended it, the I-94 on the I-797 will be the same number as the CBP I-94. It will be the same number, but the extension will not be reflected online. It will not be reflected online. So you're okay because the extension is done after you entered the United States. You're perfectly all right.
Syed says, my firm filed for my TN extension this month. My current I-94 expires May 29th. If my TN is still pending with USCIS past that, would it be okay? Or do I ask them to file in premium? It's okay in that you are authorized to continue to work for up to 240 days based on the pending TN extension. But as we discussed in the beginning, we recommend that you do everything you can to get the approval before your current TN expires, get the decision before it expires, because if it's a denial, that gives you options of filing again, filing a change of status, filing with a different employer. You have many more options versus getting a TN extension denied after May 29th. Now you have no options other than filing an appeal, which does not provide you with any status while it's pending. So I would recommend premium processing since May 29th is right around the corner.
What is the priority date expectation that it's going to boom? We are expecting some movement, but we cannot tell how much it is. It's up to anybody's guess. It's very tough for us to tell it. Question from Kark 666. I got traffic violation ticket online, mailbox, school bus on opposite side. Will that be an issue? As long as you take care of the ticket. What do you mean by take care? Whether you challenge the ticket in the court, and after that, the court will decide whether you have to pay the penalty or they may rule in your favor, or you pay the ticket, it's not a problem. But if you got the ticket and we said, and you don't pay the penalty and you don't challenge it, you just sit down, that will be an arrest warrant, though. That will become a problem. But if you either pay or you challenge it in the court, either way, you're fine.
Victor says, does self-petition EB2 NIW or EP1A require a supplement J for doing a transfer of underlying basis? No, it does not. That does mean that you're left with the old way that we used to do transfer of underlying basis before the supplement J form was created in 2017, and that was by filing a letter. The problem with filing a letter is you don't get a receipt number for it. You don't have any proof that they received it, and so you just have to keep your fingers crossed and hope it makes it to your file, or file multiple times, or follow up with your congressman office, ask them to do their liaison thing and reach out to USCIS and get them to confirm that they did transfer the underlying basis. So that's the downside of that. But no, it's not done on a supplement J.
What is the current time to file litigation once the priority date become current? Well, we can file it in within 10 days from the time the priority date is current, assuming that you have the 485 pending for at least more than 6 months. Um, can you hire our firm? Absolutely. We have Reddy, that's me. We have Newman, which is Emily. We have Brown, who is the litigation partner in it. He looks forward. That's his full time job to sue the government. That's all his main job is. So, yes, you can. Now, it's called writ of mandamus. All what we are doing is that they are supposed to adjudicate the 485 application within 180 days. That's what they told when the 485 form was issued. They said the filing fees is good enough for them to adjudicate the application. They said it's going to take about maybe 20 or 30 minutes or 40 minutes for them to adjudicate the 482 application. The processing time they said is 6 months. Now they crossed it. Now, even though online processing time about USCIS says differently, when they issued the 485 form with the Office of Management and Budget, that's not what the government told at that point of time. So definitely, that's a good thing. If your priority date is current, we strongly recommend send an email to info@rnlawgroup.com. If you want to be part of the writ of mandamus, what Stephen Brown does it very regularly, though.
Wacky Punter from X says, can the LCA be procured prior to 6 months of the I-94? Kind of. So generally, the answer is no. You can only submit the LCA, I think it's 183 days before the start date you are requesting. So that is going to limit the ability to get the LCA early. However, if you really wanted to, you can change the dates on the LCA. And instead of requesting an LCA that is from October 10th, 2026 to October 9th, 2029, you can request an LCA that's from September 29th, 2026 to September 30th, 2029. That way you can submit your LCA early. You can file your H1B a little bit earlier in that situation. The only thing you're losing is those couple of days at the end of the 3-year period. So you will get shorter than a 3-year extension if you do that. That's how we used to file all of our H1B petitions in the lottery back before the electronic registration. We would have to submit the LCAs early, otherwise we would miss the filing window of the H1B, which was only April 1st to 5th back in the day.
Basic from YouTube has it. He entered in level 3. His H1B is not picked up. Could this happen? Yes, it could happen. Even though you have 3 chances to pick up, it's just unlucky that you missed out this time. As Emily pointed out, that there are situations previously where we have seen second lottery and even third lottery too. And we think so that there may be high likely this time. One, because of a lot of different circumstances of economies going on, and also the $100,000 fees. Anybody who is outside the country, the company may not be willing to file because they may be hoping that this $100,000 they can get an exception, or maybe they think so that the court will overrule the court will say that the $100,000 is not legal. If either of those situations, there is a good chance that there may be another selection. There may be another round of lottery.
Vijay says, while moving from F1 OPT to H1B in this year, Cap, what should we be careful of? Number one, obviously, when the H1B registration was submitted, it specified a certain wage level, a certain SOC code, and a certain location. All of those things need to be aligned when you actually file the H1B petition. All of the requirements of the H1B have to be met. It has to be for a job that actually requires at least a bachelor's degree in a specific field of study. And then you have to show that the company has a legitimate, a bona fide job offer available to you. From your standpoint, switching from F1 to H1B, USCIS is highly scrutinizing the time that you were on OPT. They want to make sure that you and your company were complying with the rules regarding OPT, especially if you were on the STEM extension. Did you have a training plan? Did you comply with the training plan? Were you always paid? Was it at least 20 hours per week? Was the employer e-verify? All of those things have to be met for you to be on STEM OPT. On regular OPT, you need to be working in a field directly related to your field of study. And then they look at unemployment days. That's a big one, especially if you were in an unpaid position during your initial OPT, or you were self-employed during your initial OPT. If you're not able to document that properly, they will often assume that that was unemployment time. And if it exceeds the 90 days of unemployment time for OPT, they'll say that you failed to maintain your status, therefore not eligible for the change of status. Therefore, the $100,000 fee kicks in because they're going to convert it to consular processing. So make sure you're able to document that you properly maintained your F1 status.
Birth certificate issues, if there is the last name missing, or sometimes the name is missing, father's last name is missing, mother's first name is misspelled, not a major issue for those things, guys. I've even seen there are some RFEs, but we're able to respond and get those things approved. One of the questions that comes from Vijay is that his date of birth is not matching. Is if the date of birth is not matching, that will be an issue though. Now there are other people who are telling that, hey, spend some money in India and get that rectified. No, you cannot. The Supreme Court of India is very clear that after a certain period, I think so, it's about 18 years of age, after the person has been born for 18 years, you cannot change the birth date, no matter what. That's a Supreme Court decision. So no, no officer is going to violate it because they may be arrested and they were going to lose the job. So definitely that's not easy to, but you definitely need to contact an immigration lawyer if the date of birth is different than that of what you have been using all along. However, if it's just mom's last name is not there, your last name is there, your entire name is missing, your dad's first name is misspelled, your mom's first name is misspelled, not a major issue though. And sometimes even if your passport city, birth city is not matching with the birth certificate though, that's not an issue because most of the passports, we don't see that it's perfectly matching, and that was not an issue at all in getting the green card. But date of birth is an issue.
Anjali says, my priority date is April 2015. My daughter will be 21 in May of this year. She recently switched to F1. If my priority date becomes current in May, can I file the adjustment of status for my daughter because she would be 21 until the end of the month? So, under the Child Status Protection Act, we don't calculate her age until the first day of the month when your final action date becomes current. So if she is turning 21 on May 31st, but your final action date becomes current on May 1st, then she's under 21. She can file. But what if your final action date becomes current on June 1st? After she turned 21, she might still be able to file because for the Child Status Protection Act, you take the number of days your I-140 was pending and subtract it from her age. And so if the I-140 took 6 months to get approved, now she's only 20 years and 6 months old, and she can still file with you even though she's on F1 and even though she's actually over 21. So you have to calculate the age minus the I-140 number of days it was pending. So kind of the deadline to think about is what's the last possible day that my final action date can become current for this to work? Take your daughter's 21st birthday and add the number of days your I-140 is pending. If her final action date becomes current before that date, she's good. If it's after that date, she won't be able to adjust status with you.
Hamza Ali Marzari. I know it's a funny name. It's a movie character name. Seems to have an interesting question. He says, if the birth certificate is not available, is 3 affidavits good enough? No, that's not good enough. You need to get a non-availability certificate from the local authorities, from the government authorities. Your birth certificate is not available, Hamza.
Pratap says, I came to the US in March 2024. Now I got a full-time offer from one of the big US companies. Once my transfer is approved and I get my first 3 paychecks, can I travel to India? My current H1B visa is valid. No, 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 do not travel. It is not safe. Doesn't matter the company, doesn't matter that your visa stamp is valid. We do not recommend it.
Can I get the birth certificate from the consulate? No, it's not acceptable to USCIS. It has to be from the local authorities, that is municipality or the state government, but not the consulate. That is not acceptable according to the Foreign Affairs Manual.
Mohan says, should I wait to submit my medicals until an RFE comes, or should I send them directly to the National Benefits Center ahead of time? Totally up to you. It's your personal choice. What we have experienced over the years in these applications is if you're not seeing any movement in your application after your final action date becomes current and you want a way to potentially speed it up, go ahead and proactively submit the medicals. Get two of them, two originals, keep one with you, send one in case you still get that RFE or in case you get called in for an interview. So if you're looking for any ways, any things that you can do yourself to potentially speed up the process, I would say interfile the medicals proactively. Don't wait for the RFE, but it is a personal choice.
Second, I have an I-140. This is from Sridhar from Facebook. I have an I-140 approval with company A. I'm working for company B, but company A is willing to cooperate in filing the 485 application. Can we do it? Are there any risks? Definitely, you can do it. You don't have to be working with company A to file the 485, but they're going to test to see if you really have a job opportunity with company A, though. Is it absolutely needed that you have to join the company A for them to file the 485, for them to approve the green card? No, it's not needed. It's only their willingness to take and your willingness to join that is required for them to file the 485. But I just want you to be a little bit cautious on how you word, how you speak with the USCIS or anybody else, or any communication you may have. I just want you to be careful on that. But otherwise, technically, is it possible for company A to file a 485 when you're working for company B? Yes, as long as company A is willing to sign the I-485J, I don't see any problem.
Nitesh says, if you lose a job on H1B now, how do you stop the clock since moving to B2 is not an option? The only options are filing an H1B transfer within your 60-day grace period, filing a change of status to H4 if that is option for you, filing a change of status to any other visa category that you might qualify for, like maybe an F1. But B2 is not going to be the best option. Otherwise, leaving the country if you can't continue to maintain your status. Not a lot of good options at all.
Several questions are coming with regards to the adjustment of status is pending. Priority date is current. I want to, can I send the medicals even if there is no RFE? Yes, we recommend if the priority date is current. If you have sent the medicals before November of 2023, they have already expired. You have to resend the medicals. Now, where to send medicals? So it's not an easy answer that I can give in one line. Now, if your interview was been conducted, though, most probably your application is back in the National Benefits Center. That's where the address you need to send. If your nothing has happened on your file, it has not moved to the local office. It is not in the National Benefits Center. So I normally will send the medicals where the I-485 employment I-485 would have been filed based on your address where you are in right now. So it's not an easy one-line answer, but if you take all these things into consideration, and you may even want to chat with the Emma to find out where your 485 application is to figure out where it is. Now, they won't give an easy answer for it, but if the application is pending with National Benefit Center, I will send it to National Benefit Center. If it is pending with any of the service centers, though, I will mail it to the address where it's supposed to be mailed. Your 485 is supposed to be mailed. There is no particular mailing for medicals. It's only where your 485 has been to be mailed.
Anika says, my I-140 was filed and approved under EB3 in 2023. Is it a good idea to upgrade to EB2 or just wait under EB3 in the current situation? Well, not all EB3 I-140s can be upgraded to EB2. It depends on your labor certification. Did the labor certification require at least a master's degree? Or its US equivalent, or a bachelor's degree or its US equivalent, plus at least 5 years of experience. If it didn't, then you can't upgrade to EB2. The only way to do that is to do a new labor certification for a new position that has those higher level requirements. But assuming it was an EB2 perm, that you just decided to file an EB3 for whatever reason, then yes, you can refile that I-140 in EB2 using the same perm labor certification. It might be a good idea to do that given that EB2 is ahead of EB3 right now. We don't know if that's going to last, of course, so it's anybody's guess. But you also have to look at company ability to pay, because when they are filing the new I-140, now they have to establish the ability to pay from 2023, 2024, 2025, and into 2026. If they had a bad year in there, or maybe you were paid less than the prevailing wage mentioned on your labor certification because you're in a different position than what you were sponsored for, that could make a risky filing for EB2, and you may not want to proceed in that situation.
Emily, recently there was a publication on the amount of 485s pending. Is that right, Emily? Or am I wrong?
Yes, they just came out with a bunch of statistics. I have not had a chance to do a deep dive yet, but the new 485 inventory is out, and my very quick chicken scratch math that I did in October 2025 for EB2, EB3, India combined, there were 43,045 I-485s pending, already filed. October 25, 43,000 pending. January 2026, we've now moved one full quarter. EB2, EB3 combined for India, 44,137. So there's actually more in the backlog, not less. How is that possible? They should be approving a certain number every month to get through. That doesn't make much sense to me. So I would expect that number to go down every month until they cross January 2015, where the date already was. But I don't know what your take is on that.
When the EB1 may have gone up, filing assembly, and then maybe some fresh filings, not many.
But that's
But
just EB2 and EB3.
That's very surprising how the
Yeah,
EB2 and
it's
EB3
I've
went
never
down.
seen it go up, not down.
When the priority date does not move beyond January of 2015, that's very strange.
Yeah.
Definitely strange. What is the current timeline for getting the H4 plus EAD? My wife is planning to take a 4 months break and want to file the H4 plus EAD. The timeline is anywhere between 4 months to almost like 13 months to get a H4 plus EAD right now. Now, the good part is when you file for the H4 plus EAD, though, if you get a job opportunity, you can move back to H1B. We haven't seen any RFPs or denial when the H4 is pending to move back to H1B. Yes, we have seen that for a B2, but not for the H4.
Bonni says, I have a pending H1 extension. I filed it after I entered the country using AP. So my I-94 admit date is only till July 2026, and the class of admission is DA. When I get the approval notice, will I get a new I-94? Yes, you will get a new I-94 with the class of admission as H1B, and I assume it's just going to be maybe a 1-year extension if your priority date is current. If your priority date retrogressed after you filed the 485, then you should get a 3-year extension.
Do you advise filing premium processing for I-140? If it is EB2 and EB3, probably yes. If it is national interest waiver and EB1 A category or EB1C category or EB1B category, we do not recommend filing a premium processing right now because the chances of getting RFPs is higher if you do so.
TMSD from X says, I have my I-140 approved for my previous employer. Priority date is June 2015. However, with my current employer, I've got my prevailing wage approved, but the job description has a problem with it. So we requested a correction, filed a new PWD. What should I do if the priority date becomes current while I'm waiting for that? I don't want to go back to the old employer. Well, once your final action date becomes current, if you need to file an H1B extension at that time, you'll only get a 1-year extension. You'll no longer be able to get the 3-year extensions that you're probably used to getting. Also, once your priority date, final action date has been current for an entire year, and you still have not filed the 485, Your next H1B, where you're requesting that 1-year extension, is discretionary. It's up to USCIS whether they want to approve it or not, depending on why you haven't filed your 485. So if you can show that your new employer has started the process, they're so far in, they've already filed the perm, it's pending, they're more likely to give that extension. I've not seen an extension denied in that situation, but there is some risk there. Not a lot of options, but just something to be aware of. If you know your final action date is about to become current to where you'd only be able to get a 1-year extension, you could proactively, before necessary, file a 3-year extension, doing an amendment plus extension to see if that can buy you extra time on your H1B to get through the new process.
For a writ of mandamus, is it when the final action date is current or when you file the 485 application? It is when you file the application. However, when you file for the writ of mandamus, the final action date has to be current. So if you're filing the final, if you're filing in April writ of mandamus, it has to be final action date has to be current in April. And you must have filed the 485 way before. Those are the conditions. The final action date does not have to be current for a period of more than 6 months. It doesn't have to be.
One last question here. Aziz says, do you know what is the meaning for the USCIS case status notice explaining USCIS actions was mailed in the case of an H1B extension? Well, I can tell you if it was a premium processing and extension, and it also says the clock has stopped, the premium processing clock has stopped. 90% of the time, that means they're approving it, and it's a terrible explanation of their update. Why do they say the clock has stopped if they're approving it? Just approve it. So that's probably what it is in that situation. Otherwise, what could the notice be? I mean, it could be an RFE, it could be a biometrics notice, it could be a notice of intent to deny, it could be a notice of intent to revoke, it could be a transfer notice. Could be anything. There's nothing that you can understand from that until you actually receive the notice, and then that will tell you what it is. So you might be stuck waiting for 7 to 14 days until your company gets that in the mail.
Anything else, Emily?
I think that's it. Thanks everyone for joining us. We'll be back next week at 5 o'clock Tuesday with more updates for you.
Thank you very much for tuning.